I think we can get started with who we have here, our brain trust. I guess Sandy and Lorianne, I guess I'll defer to you here. Do you want to start with the current draft? Is that where you'd like us to focus for the to begin with?
Lorianne, I'll defer to you, but you had sent out the outstanding questions as well. So whatever you think is most beneficial.
Yeah.
All right, well, why don't we start with the ORCP and get that part out of the way, because the group was pretty much in agreement about section 2 of the draft last time, other than the reason that Matt Schrumpf and Brooks and I got together was to talk about how, was it 418? Sorry, I have a really bad cold and my head is a little foggy. It's not COVID.
Okay. Good to know.
Little off today. But basically we're trying to figure out how to deal with the summary determinations of creditor claims, how that applies to DHS. And so the main change has to do with section 2, just before the end, so it's big B. We changed that to include summary determinations under 114 also. And then we went in and updated 114.195. Is Brooks here? Is he on the phone?
No, he's got a deposition.
Matt Whitman is here.
I think Matt Schrumpf was in.
Oh, Matt Schrumpf was there, yeah.
Yeah, I'm on the line.
I can't remember. Part of the difficulty with having these meetings go so far in between is I do the work and I can't remember what I did by the time we get back together. I apologize. Okay, so if you look at section 36A, 115.195, we modified that. So we added a sub C. I am so sorry. It's just not coming to me right now.
So yeah, this is the summary determination statute.
So basically, we're trying to add in an either or. So it was, the drafting around this was a little tricky because, so subsection 2B in 115.195 has notwithstanding and it's cited to the evidence code. But since we are now exempting certain summary determination procedures from the evidence code, and some of them, we couldn't just have this notwithstanding because that would indicate that they were already subject to it. So we had to kind of play around with that a little bit to address when, for the two standards, if that makes sense.
Not an area that I deal with, and so yeah, it's hard for me.
Ultimately, the language that we're proposing just makes clear that the DHS records that are currently allowed to come in a expedited fashion can still come in whether or not the rules of evidence are going to apply, because in some proceedings they could apply and in others they won't apply. So just trying to draft around that to make it clear that whichever the case, the records still get to come in.
If it works for you all, I'm sure it works for us.
Okay. As people look at that, if anybody has a concern about that after this meeting, feel free to chime in. But for now, I'm going to go with that the group's okay with this change that we made with respect to the ORCP stuff.
Okay, keep going.
So the next big change that we made has to do with, well, that we need to resolve, has to do with section 3, and this is representation by fiduciaries and parents. At the May meeting, there wasn't agreement on this provision. So right now, the way it reads is it's talking about, to the extent there's no conflict of interest between a representative and person being represented or those among those being represented, and it's talking about who can represent and bind folks, and it talks about an agent having authority to act, a trustee, a personal representative, and then we talk about a custodial parent. During the May meeting, folks thought that subsections 1 through 3 are unnecessary in here because they're already allowed to represent and bind, like the statute or the document that gives them that authority already provides the authority, and this could create conflicting provisions. But the group wasn't in agreement, so I haven't modified this, but I'm curious how folks want to deal with it.
Anybody have any comments on that for today? Lorianne, did you say that the concern was that there would, I'm trying to remember, that 1, 2, and 3 might create conflicts with the other organic statutes that relate to these authorities?
Yeah, or it's kind of unnecessary to restate it here because a guardian already has the authority to make, to represent and bind a protected person. A trustee wouldn't necessarily, unless the trustee was named as the beneficiary in the estate, they wouldn't really have any authority there. I think, John, you had lots of stuff to say about that.
Oh, well, yeah, because while the trustee is the beneficiary, the beneficiaries of the trust do not have an interest in the probate. They have an interest in the trust. So the trustee is the party in interest. So he or she is not binding the beneficiaries. The trustee is binding itself. So 2 should come out. 3 should come out because that's just kind of the way a PR works. If you have one probate that distributes out to a second probate, it's the same situation as the trustee, and an agent having authority to represent and bind a principal is true if the power, if the document granting authority to the agent does so. Not true if it doesn't do so, so it's silly to have it in here.
So that would leave section 3 then basically just encompassing what is now sub 4?
Sub 4 needs to be there if it's going to, if that's what we want the outcome to be.
So this is Jennifer, and when I was going through this last night, it occurred to me we have this pretty complicated section about minor interested persons. Would it make sense to just have 2 sections, one for adult incapacitated or financially incapable and one for minor, and not treat them, just have them be separate other than the fact that they can be representatives? And so maybe you could just then, do we even need 4 in section 3?
So this is Lorianne. One of the thoughts I had as I was going through this, and we can talk about this when we go through section 4B, is that really if the only thing that's left in section 3 has to do with the minors and the ability of a custodial parent to represent and bind the minor, that we should just throw that into section 4B, that it doesn't need to be separate.
I agree.
If we've taken out subsections 1 through 3, there's no reason to have this separated, in my opinion.
Yeah. Jennifer, does that satisfy you?
Yes,
Okay.
I think that kind of simplifies it if we're going to get rid of the rest.
This is Judge Donnie. I just have one question on sub 1 there. It says an agent having authority to act with respect to the particular question or dispute may may represent and bind the principal. I know we have, and we talked about, if an agent's given that authority, but we do have actual and apparent authorities. And so would keeping subsection 1 in there and specifically identifying it as an agent having actual authority so that we don't run into any of the case law that discusses apparent authority, because at this point we do have two kind of judicially recognized types of agent authority.
Was it the intent by this language to distinguish between actual and apparent?
Well, I think what John was talking about was actual authority, which is to say that a principal had given the agent the authority specifically, and that would be kind of an actual authority type of decision-making, as opposed to an agent who kind of shows up, makes a representation, and if the representation meets all the, and in the circumstance meets the criteria for demonstrating apparent authority, would that create a gray area in that agent's ability to bind the principal that we could eliminate or want to eliminate by just ensuring that only an agent with actual authority could bind a principal?
Well, Lane, I don't really have any strong feelings about this, but it strikes me as under agency law, apparent authority is just as good as actual authority.
Well, that's kind of where I was going. Yeah.
Yeah, and what if you have the president of a corporation shows up and claims to be acting on behalf of the corporation? Do we want to get into, well, did your board give you specific authority to do this?
Judge?
Well, I'll agree that there is overlap with apparent and actual authority. But again, the question then becomes, the board member, I think is a great example of, squarely having apparent authority. What about, someone from, someone from, same company, an executive vice president shows up. What's the scope of their authority? What authority have they been granted? And so, yes, they have apparent authority. They may have, so I guess the question then becomes, do we want to eliminate, explicitly the apparent authority having the ability to bind a principal, or if not, then, we can leave it, as is, or just take it out altogether and not make a distinction between actual and apparent authority, but it does exist, and I'm not sure if we want both.
So, Judge, I think the question is when the agent shows up in your courtroom, which set of questions do you want to be asking? It's you're the one that's going to make the decision. So right. I don't know too much about it, but what set of questions do you want to be asking?
Yeah, and I think at this point, it's a question for the judge and the judge would have to be asking some questions. I think there's also some level of comfort that the personal representative would need to have as well. Particularly, if it's a complex estate, you may have a personal representative making some decisions regarding relatively large amounts of money and or assets and disposition of them. And do we want to ensure that at the outset, everyone who comes into the court as a representative or an agent has some responsibility to demonstrate that they have the actual authority to bind the principal they're representing, or do we want that to be a question for the court to ask and answer, or for the personal representative to maybe have to ask and answer at some point? I don't know. Like I said.
Yeah, for myself, I kind of hate to wade into agency law and make a distinction in this statute between apparent and actual, when under agency authority, you can have it either way. Granted, that means that there'll be different elements of proof of authority. But I think I would rather live with that than just to exclude apparent authority as a basis for representation? In which case, then we would just, we could do what Lorianne was suggesting. We just take that all out and move sub 4 into section 4. Does anybody have any qualms about that? My sense is sort of leave the status quo as it is with respect to agency law and not make a distinction on our own, just for the purpose of this statute.
Well, this is Jennifer, and I guess kind of looking at it from everybody's perspective, it might make sense to have a clear process for the agent to be recognized as having authority to receive notice and act on behalf of the person. And that doesn't have to be a complicated thing, but then that way the judge knows, the personal representative knows, and there's not this wondering of whether the person has authority. And I don't know if that would simply be that the agent presents, you know, a copy of the power of attorney and a motion to be recognized as representing the grantor of the power.
But if we have apparent authority, they may not. Yeah, that's the problem, I guess. Apparent authority, I think, can be proved any number of ways.
Well, and then you also have some courts that aren't going to think through apparent authority and all these other things. You have, you know, you have probate commissioners, and I think if you had more clarity of this person is, you know, there's a process and this person is recognized, then you don't have to do all this wondering if people are going to understand agency rules.
So this is Lorianne. Is this a problem right now? Are people who are trying to act under a power of attorney not having a method, a mechanism to receive notice? Is this a something that we are trying to resolve?
Well,
or just thinking preemptively trying to do something.
And this can come up because if you have someone, it's very common in an estate plan to have a power of attorney. You give somebody these kinds of powers over your financial resources. And if you don't have someone who has clear authority to act, then you're in a position of having to either get a full conservator or a conservator with specific powers. And that can be, you know, expensive and you know, just kind of takes a lot of extra time. Whereas if this is part of the estate plan already, and you simply have the court bless the power of attorney, then that person can act in a simple way.
And Jennifer, are you talking about the beneficiaries of the estate?
Right. Well, that's mainly what I'm, well, it could apply to a creditor too, but I'm thinking about the beneficiary. So let's say you have a devotee in a will, and that devotee had a stroke and is 55 years old and is in a care facility, and his or her affairs are being managed by an agent under a power of attorney. Well, then that agent could get the power of attorney recognized, could receive notice, could consent to the verified statement, could conceivably even receive the distribution out of the estate pursuant to the power of attorney, because that person's already managing the resources of the you know, the stroke victim.
Tell you what, let's put this conversation on hold and take a look at 4B, the options, because even there still may be something we can just fold into that.
So for 4B, I have two different versions.
Right.
The first one is, I think, what we ended up at last time, but we didn't really make any decisions last time. So it's it was difficult for me to try to incorporate what the group had discussed. So the main change in this is I added in for the representation to include a court-appointed guardian and conservator rather than a guardian conservator appointed under Chapter 125, because there were some concerns about foreign appointments and whether those would be recognized. I also added in an agent under a power of attorney. Then we added in a subsection 2B which just says that paragraph A of the subsection doesn't apply to notices required to be delivered under 113.145. That's a notice to heirs and devotees and interested persons. I'm not really comfortable with that being in this section because this section doesn't actually say anything about notices. So how would subsection 2A not apply to notices when it's just talking about, it's trying to put out their representation. So it doesn't quite flow naturally. So then we've got subsection 3 says that if a court appoints both a guardian ad litem and special representative for an interested person, the court shall appoint the same person. I just reworded that slightly so that it's clearer. So those are the main changes where I was trying to incorporate what we had talked about last time. But then I still have questions and concerns about this. Mainly the main issue has to do with, we're saying that a person has to be, we're making this a requirement.
Right.
That a minor has to be represented by an interested person who's incapacitated or a minor has to be represented by one of these people. But who's enforcing that? Who has the duty to ensure that they are represented? We haven't talked about that. Is it on the PR? Is it on the court? And I think it creates a lot of ambiguity about how that's dealt with and the timing that it's dealt with. So I redid subsection 4B. It's listed as option 2. And basically what this does is it says that an interested person may be represented by these people. So it puts in there that there's authority for this representation. Then it goes on to say that if the person is a minor, that the minor's custodial parent can represent them pursuant to subsection 4C, which is the minor interested person section. And then subsection 2B gives the court the option, the discretion to appoint one of these people for an interested person. So it doesn't make it mandatory except for if the interested person is a minor and the court determines that the minor's interest is not adequately represented, then the court are required to appoint either a guardian ad litem or a special representative. So that gives the court the option that if they determine that the custodial parent isn't, there's a conflict of interest or maybe they're not able to do it properly, the court has the authority to do that. And it can be on the court's own motion or anybody else's motion.
Yeah.
I think those are the main differences between the two provisions. So just to restate that, the version that y'all saw last time made it mandatory that if you're incapacitated or financially incapable or a minor, that you're required to be represented by one of those people. It doesn't say who has the duty to ensure that you are represented by those people, which creates a problem. I just feel like it's not really dealt with. We haven't sussed that out. The alternative language that I proposed, it allows for these people to be represented. So it says that they may be. So it's giving the representatives, the authority to represent them. But then it gives the court the discretion to appoint if the court determines that it's necessary.
Yeah. What are people's reactions to 4A and 4B?
This is Judge Cobb. If we have the second option, looking at capital letter B, if the interested person is a minor, by the minor's custodial parent is provided in 4C. So that's the assumption that you're going from, that the custodial parent is representing the minor?
So under 4C, it says that the custodial parent may represent the minor if a fiduciary hasn't already been appointed.
But in this, let's say that a fiduciary has not been appointed, and so the presumption is that the parent would be representing the minor, correct?
That seems to be correct.
Okay, and then you go down to capital B, small c, that the court has to determine if this minor's interest is not adequately represented, how in the cat hair am I going to do that? How would I possibly know that their interests are not adequately represented?
Well, it's permissive, so it doesn't say you have to.
Right.
So I guess it would be if, yeah, I'm not sure what circumstances you might become aware of the questionable character of somebody, of a custodial parent who's acting on behalf of a minor, but it gives you the authority.
And it's also on the motion of any other party besides the court's own motion.
Right.
Well, I'm mostly concerned about what the standard is for not adequately represented. And this kind of dovetails into my other question in this section, that it keeps talking about the possibility of a conflict of interest. What standard is that? And I'll give you the basis of my concern is we've got parents who were divorced, and father used to have custody of the child and he's dead, and so mother is now custodial parent, and she, you know, now has to pay for these kids, and they're coming into a large amount of money. And is that a conflict? How would the court possibly know what a conflict of interest is?
Well, this is Jennifer. I don't necessarily think that's a conflict, because down the road, the court is going to say, how is this money going to be held on behalf of these children? And it may be that the court says, we need to have aunt be the custodian for those funds, or the conservator, or whatever. Just because the mother, you know, goes along and signs a verified statement or doesn't object to attorney's fees or whatever, doesn't necessarily mean that, you know, that's going to entitle the mother to have those funds.
You know, my question becomes, we're giving the custodial parent all kinds of authority to receive notice and to do this and that and the other thing, and it appears that there's a conflict of interest, or the conflict of interest is the standard. And, you know, the personal representative has three different responsibilities to, you know, find out this conflict of interest. And conflict of interest goes all throughout this, including talking about it's voidable unless the action is approved by the court. So I'm concerned that we've got this nebulous concept of conflict of interest. The fact that mom, you know, is looking at the $4 million that the kids are getting with dollar signs in her eyes, is that going to be a conflict of interest, especially with under the statute that we've got, that if the court approves in excess of $30,000, she can have everything in a custodial account. And I've seen a number of those. And all of that concerns me, that we're talking about a conflict of interest, especially under the, first of all, a parent has a primary duty of support of the child. And secondly, under the guardianship and conservatorship statute, the standard is best interest. So it seems like we're switching that now, that it's not the best interest of the child, it's this nebulous conflict of interest.
So this is John. Can I chime in to support that? I think the words conflict of interest should come out of this altogether. People are not, you know, lawyers have conflicts of interest. Politicians sometimes do, sometimes don't, but real people don't. And just because somebody has what somebody else might think is a conflict of interest doesn't mean that they can't represent the person adequately. So I think conflict of interest just raises a lot more questions than we want raised. And I think you just substitute something that, you know, the court won't appoint, court will not appoint somebody as a special representative if the court believes that that person is not going to adequately represent the interests of the protected person. And if it's, you know, if you've got a really strong conflict of interest, then you you easily get to the point that it's not going to be an adequate representation. If it's just a technical conflict of interest, it doesn't affect the representation, you can ignore it. So I think that gives the court the flexibility to make sure that the person acting on behalf of the protected person is actually going to be furthering the protected person's interest.
Judge Cobb, how do you feel about that? Changing conflict of interest to some sort of a finding about adequate representation?
I guess I don't know what the exact language would be, but I think that if there is the best interest of the protected person, or the best interest of the minor, I should say, that would coincide with the fiduciary responsibilities that we're going to impose on the parent and the statutory obligations of fiduciaries in Chapter 125 to be consistent.
Well, this is Jennifer, and just so that you know the source of that phrase, conflict of interest, that was from ORS Chapter 130, the Trust Code regarding representation, which is where we were kind of trying to bring those ideas about representation into the probate statute, but maybe conflict of interest comes up more easily in a trust situation than it does in an estate situation.
Actually, it also was modeled on the Uniform Probate Code, section 1-403 sub 5. So it's almost verbatim from the UPC. But the UPC also doesn't say what a conflict of interest is. So for whatever that's worth.
I was going to point out that the Uniform Probate Code does not in anywhere, and that's been controversial in the Uniform Probate Code as well.
All right.
Would it work to just use the standard in the best interest of the children and then have that be kind of consistent with Chapter 125?
Well, except in 4, it's not just children; it's other persons as well. So.
Oh. Well, it could be the best interest
Yes.
of the representative person.
That's right. Yeah.
And
All
then,
right, sorry, go ahead, Jennifer.
well, and then the other thing is in the special representative appointment, it does allow the representative to consider the family interests or something like that. So there's all these weird nuances that come up.
So what if we do this so that we can move forward? I'll take another shot at subsection 4A that's talking about the conflict of interest and try to mirror that more closely to what we use in Chapter 125 using the best interest standard. And then y'all can take a look at that again.
Well, let's decide first if we like 4A or 4B better.
Well, it's option 4B, but option 1 or option 2. So,
right, sorry, yeah.
yeah, option 1 being what
right.
y'all have seen before and option 2 being what you're seeing now for the first time.
Let's give Lorianne some guidance there between option 1 and option 2.
I have a question that relates to this. I thought that one of the issues that these were trying to address is when you are issuing notices as the PR and you have somebody that you know is a minor or know is incapacitated, has a guardian or conservator, who are you giving notice to the minor and or protected person, or to that person's custodial parent or guardian conservator? And then I thought that Judge Burton was raising concerns about somewhat similarly about if you have someone who's a minor or incapacitated, then how can that notice be effective? And so I thought that was maybe the source of the must language in option 1. I'm not taking a particular stance on it, but I thought that that was kind of the background to this. And if 4B, whichever option 1 or option 2 is not meant to address notice, then are we addressing that somewhere else?
Well, let me try another way at this and see if this helps. I mean, if we go back to the definitions in Chapter 111.005, interested person includes heirs, devotees, children, spouses. It's the whole waterfront. And it says interested person also includes fiduciaries representing interested persons. That's going to carry all the way through the probate code. So wherever an interested person is entitled to notice, I read this as including fiduciaries representing interested persons. So if the PR knows of fiduciaries, then it's the PR's responsibility to include the fiduciaries in notice. And I think that's already covered.
Also,
I'm not so sure about putting the fiduciary in the PR in the position of having to go out and secure representatives for unrepresented beneficiaries or creditors. That seems like a pretty high burden to impose on the PR. Certainly where the fiduciary has been appointed, the PR knows about that, then that fiduciary gets notice. I don't know. I for one, think that must standard is pretty strong and at least infers an obligation on the PR to do the work.
and just to address Matt's question about whether we deal with who gets notice somewhere else, that's in subsection, or section 8 talks about who gets notice, and it requires that notice be sent to, if the person is a minor or financially incapable, it goes to the person if the person's over 14, but it also goes to the person's conservator, or if the person doesn't have a conservator, it goes to the representative identified in section 4B.
Okay.
So it cross-references back to this, but that's the way it reads.
Well, and I agree that that's one of the reasons we're having this discussion is we want the notice to be effective. So at the end of the proceeding, we want to be able to say that the minor received effective notice, that the probate's distributed and it's all done right. We don't want somebody to come back later and say, well, the minor didn't have a representative and these, these letters were being ignored, and somebody try to undo the probate or the incapacitated person.
Okay, we'll deal with who gets notice then, in more detail as we get on. But back to 4B option 1 and 2. What's the preference of the group? To give Lorianne some guidance, and then she can work on that conflict of interest language and modify that to address the the interest of the minor or protected person.
If it's not mandatory, this is Judge Cobb, if it's not mandatory, then, because this is limited to people who have guardians, conservators, or who are minors. And if it's not mandated, then kind of what's the point of option B? If Jennifer's, if the point of this is to make sure that whoever gets notice, whoever signs off on things, who's ever acting in a certain way is definitive and the attorney and the personal representative can count on it, then why not make it mandatory? Because we're limiting this to guardians, conservators, and minors.
So then that begs the question that I think Lorianne asked early on under option 1. If it's a must, who's responsible? Who has to do it?
And
I would think
what
that
happens if you don't have one?
Well, that's what I mean. Yeah.
Yeah. Does the whole probate stop?
And does the PR have to go out and find a representative if there isn't one? That's
if there isn't a
guardian
guardian,
about must.
if there isn't a guardian or conservator, then why would the personal representative have to go out and find one? And if a minor is a minor and they have a custodial parent, I don't understand the difficulty.
I guess on the guardian conservator side, are we saying the hypothetical is there's enough reason or knowledge that the person is financially incapable, but for whatever reason, no guardian or conservator has been appointed for the person? And so then does the PR, since there's no guardian or conservator appointed, do they have to ask the court to either appoint one of those or appoint a guardian ad litem or special representative?
And then who pays for it?
Mm-hmm.
Is that what the intent of this is that if you think somebody's incapacitated, you have to go into this? You have to give them a representative, or you maybe have to give them a representative?
That's how I read option A.
Well, this is Matt Woodman. I think, Your Honor, I think that is exactly what, that's exactly what this is aiming to do. If, and by the way, I don't think this is, what this puts in place is too different from the standard of care right now. If I represent a PR and we want to give notice of some controversial action, and we think that a beneficiary is someone who doesn't have the capacity to receive that notice or consent to the controversial action we might already take, then, and I want to protect my PR who is who's a fiduciary, then I'm going to seek the assistance of the court to make sure that that person presently has representation.
Yeah, this is Judge Donahue. I mean, I think I like option one, and the reason why is because I think as a legal policy, one of the things this court, I think we want to do is we want to ensure that if you're a minor, you're incapacitated, you're financially incapable, you get adequate representation during a probate proceeding somehow, either through the PR making a determination or the court having to do it on its own motion. But just as a policy matter, we don't want to have a probate that, you know, we don't want to have a probate code that would not put some requirement on the people directing the probate, and there's generally two people there. One, the personal representative who's the administrator, and then there's the court that's the final decision maker, not having some requirement to make some inquiry and as to whether individuals who may be incapacitated or who are minors aren't having their interests represented. So I think making, you know, having the must in there and giving the court and the personal representative some responsibility to do that just from a policy standpoint seems to be where we would want to go.
Lorianne, you raised the issue about that language. It is passive voice, isn't it? It doesn't say who must, who's responsible for this.
Yeah, so we need to make a policy decision on what that looks like, when to come into play. Does the PR, I mean, the PR doesn't really have authority to do anything until they're appointed. So they must have to, ask the court to, do they file a separate petition to open up a guardianship or a conservatorship if they think that somebody, you know, there's an incapacitated person who doesn't appear to have a power of attorney? What does that look like in practice? I mean, I know, Matt, you were saying that this kind of mirrors what you're supposed to be doing anyway, but we don't have a requirement necessarily that the PR has to do something. And if we're going to put it in statute, we need to say when that requirement kicks in so that they know what their duties are.
Well, but this is section 2A, and it says if an interested person is incapacitated, financially incapable, or a minor. And those are legal findings. I read that as saying you've got to have a guardian or conservator, or obviously you're under 18, in order for this mandatory part under section 2A.
And I would, and this is Judge Johnny, I mean, I would think it would be just as simple, you know, the 2A looks to me to be as simple as most, you know, as the person representative once appointed identifies the interested persons, makes a determination that one of the interested persons may be incapacitated or financially incapable or a minor, and then moves the court for a determination to that effect. And then the court makes that determination and determines, because they are incapacitated or they are in fact a minor, this is what the conservator will be appointed, or the parent will be, the parent representative or a special representative will be appointed. I mean, it seems like that would be the process, and it would be relatively, I don't think it would require a separate petition or anything like that. It would just be a motion within the estate proceeding itself, made either by the personal representative or by the court if the court gets information to that effect.
So would the personal representative make that motion concurrently with a petition for appointment, or is that it's after they've been appointed that they then ask the court?
I think it'd be after appointment. Up until the point where the personal representative is appointed, that responsibility doesn't statutorily attach to them. It attaches to the position of personal representative, which is a legal construct. So once that legal construct's created, the person who's in that legal construct has to go forward and meet all the duties of a personal representative, one of which being identifying whether they believe, and there's we can import some sort of good faith standard there, that persons they've identified as interested persons are either incapacitated, financially incapable, or minors. Bring that to the court, and the court can make a determination. Or the court can do it on its own if the personal representative brings information that the court then looks at.
Well, but of course, in so many of these cases, that person might not agree that they're incapacitated or financially incapable. And so does that implicate the due process in Chapter 125 of the visitor and notice and an opportunity to object on the part of the person who is believed to be financially incapable or incapacitated?
Well, this is Jennifer, and another way of looking at this is, let's just say, and I had an estate like this. It was one of the devisees was incapacitated. My client, the PR, recognized that he couldn't manage the money. I said, you need to have a conservatorship. Before the estate was closed, we got a conservator appointed, and the conservator, received the benefits out of the estate. And so that is more likely what's going to happen. If somebody's going to need to receive something, you're going to get a conservator appointed, unless it's such a small amount of money that you only need a custodial account, for a minor.
Getting complicated.
Yeah. But I do agree with Judge Donahue that, we don't want to just ignore the rights of these incapacitated or financially incapable people, and just kind of, like we've been doing, you mail a letter to the care facility where they don't open it and they don't know what it says and they don't understand it, but technically you've mailed the letter.
So can I chime in here, this John? I'm 100% practical about this stuff. So I think if what I think would be workable would be if we want to know that everybody's represented, then after appointment of the PR, if there are any beneficiaries who are incapacitated or minors or something, then somebody has to step up and acknowledge that they're representing that person. And I think it's sensible to require the PR to do something in order to make that happen. But I think we ought to be a little easier on the PR here. I'm kind of concerned about the language about if a person is financially incapable. That's a fact.
Right.
And it's a fact that nobody may have determined. If somebody appears to be just fine, but they really are financially incapable, how is the PR supposed to know that they need to get a representative for that person? Do we have to go get a judicial determination of competency for all our beneficiaries? Because incapacity can be hard to spot. So I think it should be more like if the PR has reason to believe that a person is incapacitated or financially incapable or is a minor, then they have to do something to get representation. A lot of people claim to be 18 when they're really 17. How are you supposed to know? Yes, you have to research everybody's birth certificate or something. So I think, unless the PR has some reason to believe any of this stuff, there shouldn't be any obligation. And as long as it's this, factual approach of is this or is that, then I think you run the risk that nobody notices it until the end, and then everything that's happened is retroactively no good. And you have to go back and start all over again.
So John, you would say that if upon appointment, so this is after appointment,
yes,
PR has reason to believe that, an interested person is incapacitated, financially capable, or a minor, and you're going to put this on the PR, then the PR must what then? Ensure that a representative is appointed, or what does the PR do then?
Well, good question. I don't know.
This is Judge Johnny here again.
How much of a burden do you want to put on the PR?
Well, I think at the end of the day, incapacitated, financially incapable. I agree with John. I think it is who said it. Those are legal determinations. I think what we want to do is incentivize personal representatives to bring concerns to the court as early as possible in the probate process, and let the court make a determination as to whether, yes, the person is incapacitated. Then maybe a conservatorship proceeding needs to go forward, or they are financially incapable, or they are a minor. So I just think, I don't know if we need to put a lot of burden on the personal representative to do these things. I think what we need to do is just incentivize in the statute the personal representative to come to the court as early as possible with these issues, so that the court can make the determinations kind of at the head of these proceedings as to whether or not there are financially incapable, incapacitated, or minors who need representation, and get that dealt with as early on in the process as possible. So I wouldn't put a lot of work on the personal representative to make these determinations. I would, though, kind of try and incentivize as much as we can through the statutes a incentive, some way to get to basically give the personal representative as much incentive as possible to make those reasonable belief determinations early on, and then bring those to the court for the court to make a determination.
But let me just ask you, what if that beneficiary or interested person is out of state? The court doesn't have jurisdiction to bring them in to make any inquiry or finding, or even the ability to do that.
At that point, I think that would be kind of, no, go out. Judge, I didn't mean to cut you off.
Sorry, I was just saying, doesn't that, to Lane's point about being out of state, that the court would be able to appoint a representative to represent that individual? I don't know that I have to go find, whatever the statutes are in Connecticut as far as capacity or financial incapability, but I think I certainly, if issues were raised about, John suffering from a stroke and is in nursing home in Connecticut, I could appoint a representative for that person. Sorry, Judge Donahue, you go ahead with your point.
No, that was actually my point, because we were talking about what a special representative is, and that is someone who may not have the authority to go and do things that a conservator or a guardian might, but would have the authority as a decision maker within this probate proceeding. And it would seem like the court would have the ability to appoint a special representative for that out-of-state person. But again, that is another legal policy question.
So this is Lorianne. So just trying to figure out how this looks what this looks like in practice. You're saying the PR is appointed. The PR goes ahead and they send out the notices to interested persons. As they're doing that, they have reason to believe that, they learn something about some interested persons that makes it, they're not sure, but there might be an interested person who's incapacitated or financially incapable, or one that's a minor. So then they move the court for a determination of whether a representative needs to be appointed, but it's not necessarily a motion to appoint. Is that correct? What is that? Like, what does that, because is it, so if it's a minor, maybe the PR is asking the court to authorize the custodial parent to receive notice.
Right.
And if it's an adult, is it that the PR is moving the court to appoint a special representative?
And if it's on a finding of financial incapacity or incapability or incapacity, again, don't we have due process rights here where that person has to be given the opportunity to contest that finding? They may say, I'm fine. I don't want a special representative. And
So what would be the problem if anybody didn't want a special representative? The minor doesn't like the idea that they want to be represented by their parent. They say, I don't want to have my parent. I mean, that's the same kind of thing then that it would be a determination of the court.
Minor, if you're under 18, you're a minor. If you're not, that's pretty straightforward. It's the financial incapability and the incapacity that becomes, those are factual determinations based on, all the host of circumstances we see in guardianship and conservatorship proceedings.
Right. Well, I don't think there'd be anything under the statute that would prevent that person in Connecticut from filing a response with the, would basically respond to the court and say, no, I'm not financially incapable. I don't want a special representative appointed for me. And then the court would address that issue. But it would be within the context of, we're talking about probate proceedings for the distribution of assets within the state of Oregon that exists within the state of Oregon that were devised by a will that was, drafted in the state of Oregon. So I think we could still have the due process addressed of not wanting a special representative. The question would be, I think the question we started on was, what about the person out in Connecticut? What would the personal representative have to do? And I think there would be a mechanism for the personal representative to bring that to the court here to make a determination on a special representative appointment, and that person having due process in front of the court in Oregon to contest that and make a determination that they don't need it, and the court make a ruling. That would be binding for the purpose of whether or not they represent themselves or have a special representative making decisions for them in this particular estate.
So my concern here from a practical standpoint is if I'm the PR and I'm administering this estate and I get to a point where I want to make a partial distribution or I want to do something, sell a property or whatever, and I think I'm going to do a final account and I need to notify and perhaps get consent from beneficiaries. At that point, when I need something done by the beneficiary, if I've got a minor beneficiary, I then go to the custodial parent and have the custodial parent sign the document on behalf of the child, and that's option 2 works that way. If we go with option 1 and we have this must be represented language, then I think the logical extension of that is going to be that I have to, as the PR, I have to make sure that every minor and every incapacitated person has an official representative at the beginning of the proceeding. And if I don't get them all represented, then I don't know if I can administer the estate until I do. So, and that's my worry about the must language.
Right. And again, this is Judge Donahue. I think that, but again, I think Laurie was talking about, kind of importing a reasonable, was talking, I don't know if this is in relation to option 1 or option 2, importing that reasonable belief, which would kind of be a bit of an escape clause for the PR, which is if the PR reasonably believes the person's a minor, reasonably believes they're incapacitated, it puts some due diligence on the personal representative, but on a reasonable belief standard, which then gives them some escape clause. They don't have to do an exhaustive search. They have to do something that would be considered reasonable for a person representative in those circumstances to make the determination. And if doing that, they don't believe there's no financially incapable, incapacitated or people or any minors, then they can move forward. So I think that reasonable belief standard to some extent may address that. And I agree. I mean, I think we're not going to come up with a statute that's going to take care of every circumstance. I don't think we ever can. That's why we have appellate courts. I'm just thinking, you know, as a legal policy, do we want to make sure to the greatest extent possible, everyone who's subject to potential property distribution in an estate proceeding has legal representation if either the person representative of the court reasonably believes they should have it. So.
This is Judge Burton. Can I just jump in? I'm late to the party.
Welcome.
Regardless of what we do in the statute, there's a due process issue here. And I don't care if you've complied with the statute. If you have a minor or incapacitated person who surfaces later and they didn't get notice,
yeah,
you're going to have a due process issue.
That's true.
Yep.
Yes. So I think the idea behind requiring as much work to be done up front as reasonably could be expected will minimize the potential for those due process issues to come later in the proceeding and potentially grind it to a halt for a period of time. And I think that's all we can do.
This is Lori. Sorry, go ahead.
I was just going to tell one more story that, you know, because that's what we all live by, is I had a case where, I had a minor beneficiary of an estate and I approved a wrongful death settlement and some attorney's fees. And I later appointed I can't remember, counsel or representative or something for this minor because the trust that was supposed to happen wasn't happening. And that attorney came back and said, these attorney's fees are outrageous and shouldn't have been approved. And I was stuck with, okay, I approved them, but this beneficiary is a minor and never got notice and wasn't represented. And I don't think what I approved was valid. And I wound up undoing what I had already done. And so that's the risk that you're taking every time you don't find out that somebody is incapacitated or a minor.
So this is Lorianne. What if we were to go with option 2, which talks about, it's not mandatory, but it talks about, you know, these people may be represented by these people. If it's a minor, they have to be represented by so-and-so. What if we also have a provision that says that if after appointment, the PR has reason to believe that an interested person is incapacitated, financially incapable, or a minor, the PR shall move the court for a determination of whether that person has to be represented as provided in 4B. Would that resolve these concerns? So there would be, you know, at the outset, that the PR would make this inquiry, and then if they know or have reason to know that an interested person is incapacitated or incompetent or a minor, then they then move the court to make a determination that that person has to be represented by one of these people listed in 4B.
You know, going back to Judge Burton's comments, this almost, it hurts my head. Yeah, what we're really doing here is creating a statutory framework to assure compliance with constitutional due process standards. You're right, they exist outside of this language entirely. They're there, they're there. And I guess what we're getting wrapped around is to try and get in and develop the specifics of a process that is intended to assure compliance in all cases with those constitutional due process standards. And that's new.
I think what Lorianne's proposing sounds to me good. because I think the idea is I don't think we're going to be able to address the due process issues in the probate statute. I think that the goal should be, from a legal policy standpoint, is to address potential issues where which may implicate due process as early as possible in the process. So that I think would be what we'd be looking at doing here. Not so much trying to import all the due process protections into the probate statute, but just make sure that the personal representative addresses those issues as early as possible if something comes to their attention that in their reasonable inquiry implicates a potential due process issue that could derail this estate later on. And I think that Lorianne's her proposal would do that at least is in the context we've been discussing it.
So Lorianne, yours would be then to leave option 2 as it is, but then you would add a new section that basically says that if the PR has reason to believe during the course of the administration of the estate that an interested person is a minor or financially incapable or incapacitated, then they bring that to the court's attention for the appointment, determination of the necessity of the appointment of a representative?
Yeah, so it wouldn't necessarily be that the court would then be making the appointment, because it could be that a conservator is appointed, which would be a separate.
Right.
So it would be that the court makes a determination that a representative is required. And then that would then prompt, a decision about whether you're going to petition the court for a GAL or a special representative, or whether the custodial parent is sufficient to represent the kiddo. And we could set it up so it's like within that 30-day window that the PR is doing a whole bunch of stuff at the beginning of the probate, and then at any point thereafter, if the PR then learns of somebody else that.
How do people feel about that? I think I want to say yes just to get us, because I think it sounds good, but I also want to get off this section. Are we willing to look at that?
This is Jennifer, and I think that's a good start to the approach, but here's a practical question. So let's say we do that. Let's say the court does say, yes, a guardian ad litem or whatever is needed, and the incapacitated person has no funds, then who pays for the guardian ad litem? Or the special representative, or whoever is the representative, because it'll be a professional, probably.
Could that fall into the public guardian?
No.
Could we make it?
Well, or do we go that far? Do we just, at that point, is that where we sort of cast even the boat off the shore and you guys figure it out in each case?
This is Brian. I think if we were to throw it to the public guardian, that would be a fast way of killing this bill.
Yeah.
The public guardian can't even do what they're supposed to be doing now.
Right. They don't. I handle their cases. They don't have the funding to take on anything additional. They heavily prioritize cases with, serious physical dangers to individuals. So, and they've not done any conservatorship aspects so far, because with their limited budget, the physical safety is, sorry about that. Physical safety is more important. But this strikes me as, I will pause, I can't concentrate.
Well, this is Jennifer. In the meantime, while Matt's getting the dog issue dealt with, which I have here as well. Obviously, if the person is entitled to receive something from the estate, then there are funds available to pay for this. But does that violate some sort of constitutional right that their funds that they have access to as a potential distribution down the road are being used to pay for this representation?
Well, how is it dealt with right now? This is Lorianne. So what's the status quo right now if you've got an interested person who is incapacitated, needs a conservator appointed, but they don't have money? What happens right now?
I'm going to guess that just work it out.
Well, if by work it out, you mean we just go ahead and we get the judgments that we want and then take care of, and hope that we have insulated ourselves appropriately from collateral attacks down the road. Yeah. No, I mean finding a way to get somebody appointed. Well, I mean, to Jennifer's point about, oh, if they, maybe there are funds available to pay them, we're talking about giving notice that's required by statute, including notice to people who may not be getting any money out of this estate.
Well, that's not really what I mean. What I mean, yes, we have to give them notices. That's just extra cost to the PR. That, to me, this is more administrative expense in this estate, and that's just the cost of doing business. My concern is, let's say the court does say, yes, we need to have some representative for Johnny, adult John. We have to have some representative for adult John. It's in there. And the only person that can serve is professional fiduciary as special representative or guardian ad litem. And it's going to cost, $1,000. It would seem like that should come from John's share of the estate, but can we direct that?
Well, Matt made the great point. This might be all about giving notice to people who don't get anything. So if you've got, and that happens every day of the week, you have a petition, you have a will that leaves everything to people other than the heirs. And the heirs get notice because they theoretically have the right to contest the will. So if one of the heirs is incapacitated, do we have to spend estate dollars on getting representation for the heir so they can make an intelligent decision about whether or not to contest the will, which they're never going to succeed at, but it's a way for the representative to get paid?
I think that's why there's an exception in the draft to it not applying to the statute requiring.
That's right.
Yeah.
Yeah, and if we say upon appointment, then the PR has to, then that also would still exclude that initial notice to, at the beginning of the probate.
Yeah, but that doesn't solve it 100%, Lane. You got your notice out, and you find out that one of the heirs that you sent notice to is incapacitated, or whatever, you can't find them or something. Now, do you have to? You're appointed. And now you have an interested person who is incapacitated, and you have good reason to believe it. Do you have to go get a representative appointed for that person so that a decision can be made about whether to contest the will? And then who's going to pay for it? I got clients that cut out their heirs every day of the week. They leave everything to they leave everything to their second wife, or they leave everything to their boyfriend or something, or charity.
Well, so would this work maybe to give the court authority to not require that kind of representation for good cause or something?
This is Judge. That go back to Claudia, Judge Burton's point about due process.
Yeah.
Mm-hmm.
Yeah, I'm going to agree with that. I just think, and unfortunately, I got to jump off here for a few minutes. But I mean, I think at the end of the day, the question we got to ask is, do we want to address these issues up front? Is the cost-benefit analysis addressing these issues up front, or do we want to some extent whistle past the graveyard and hope nothing happens? And if it does happen later on, have to unwind what could be property distributions that have already been made, and court awards of fees that have already been made. And I guess that's the question we have to ask ourselves. And it seems like doing it as much up front as possible, even though that might create some problems, would be the better way to go about it.
This is tough.
Well, that's certainly the more prudent approach, but I'm more of a ask forgiveness later type of guy. The problem is
it's the cost benefit question too.
It's always a financial risk analysis. If you have an heir who's theoretically capable of contesting the will, but they're not going to, and you violate their due process rights by not getting good notice to them, you take that chance. And if they come forward later and try to unwind the whole proceeding and contest the will, then okay, you lose. But they're still not going to contest the will, and they're probably not going to because they know they're not going to win. So all this theoretical potential can get very, very expensive. So, and if you got a beneficiary who gets $1,000 and you're going to give them the $1,000, and if they're incapacitated, do you have to get a representative to make sure that there's no question about which form of currency the money was? You know, it's going to cost more to represent them than the gift warrants.
Don't you think that that could be resolved in that motion for the court to determine whether the person has to be represented? I mean, you could make you could indicate that, hey, this is a specific there's a specific bequest. It's $500. Do we really need to appoint a representative for this person? Because it's not mandatory now that the person has to be represented. Right?
Right. All right, let's do this. We've got to get off this section. Let's ask Lori Ann to redraft option 2 the way she's described it. And you know, respecting our conversation about it today, let's take a look at it next time. You know, I think we could talk about this for the rest of the 40 minutes left to us and still not come to a resolution. I think we need to see some language, and let's react to that. I think Lori has given us a good analytical approach to it anyway, a structural approach, and let's move on. So Lori Ann, you'll also address the conflict of interest language. You'll change that over to interest of the protected person, that kind of thing.
Yeah, best interest types.
Okay. All right, let's go on to 4C.
All right, so 4C is dealing with minor interested persons. So it says that if an interested person is a minor, the representative shall, so it's required, make a reasonable effort to determine the name and contact information of the minor's custodial parent and whether the guardian or conservator has been appointed for the minor. Then we've got any notice that's required to be delivered to the minor must be delivered to the minor if they're 14 or older, and the minor's custodial parent, and any fiduciary that's been appointed for the minor. So that's a policy question of whether you still want the custodial parent to receive notice if the minor is represented by a fiduciary. That's one question that needs to be addressed. And then we say, if after reasonable inquiry, the PR is unable to locate a custodial parent, and a fiduciary has not been appointed for the minor, the PR has to move the court to appoint a guardian ad litem for the kiddo. And question is, do we want it just a GAL, or do we want it to be a special representative or GAL? How you want to deal with that? Then the next provision, subsection 4, deals with, it says that if there's no court-appointed fiduciary, that the minor's custodial parent may represent and bind the minor. So this is that language from subsection 3, or from section 3, that if we get rid of the section altogether, that's where that shows up for the minor. Then a question is whether we want to say that certain acts require the court's approval that the custodial does on behalf of the minor. 4C says that if the distribution exceeds, if the amount that the kiddo is going to get from the estate exceeds the amounts for under UTMA, or sorry, for the transfer minors, that there's certain procedure that has to be completed that involves the court's approval. Then sub C has, or sorry, that should be sub D. Question of whether we want to limit what the custodial parent can do on behalf of the minor, just outright say they can't do that. That's a policy question for y'all. And subsection 5 is that the right of the parent to bind the minor is suspended as soon as there is a court-appointed fiduciary, unless the court otherwise orders. So it kind of gives flexibility there if there's some weird situation that we can't anticipate right now, that the court would still want the custodial parent to have the authority to do something. Subsection 6 talks about this gets into the conflict of interest again. And again, we can revise this to deal more with that best interest of the kiddo. And it provides that no later than 3 business days after becoming aware of an actual or potential conflict, the custodial parent's required to notify the court. Also, the PR is required to notify the court if the PR reasonably believes that there's a conflict. The court can take any action it determines necessary to resolve the conflict. This language mirrors the language that the work group provided regarding the appointment of a special representative. Subsection D, paragraph D, talks about if the custodial parent takes action on a minor, on behalf of a minor that is affected by an actual conflict of interest, that action is voidable. So that can be undone. But yeah, so that's the minor beneficiary section. So maybe we can start back at the top.
Let's do.
So section 1, so if the interested person's a minor, the PR shall make a reasonable effort to determine the name and contact of the custodial parent and whether there's a fiduciary appointed for the kiddo. Is everybody okay with that, requiring that on the parent? Or sorry.
On the PR, yeah.
Yeah, thanks. Does anybody have an objection to that? Nope. I'm gonna say no.
Yeah, I think you're good.
Subsection 2 is that this.
Can I interrupt for one thing? And this is a question that I've had all along, where we talk about custodial parent. So if you have 2 parents who are the parents of a child, they're married, they're living together, are they both custodial parents? Is there a law that defines them as custodial parent?
There's no law that defines them as custodial parent, no. But if you've got 2 parents who are living together with the kid, then there's really not a dispute about who the custodial parent is there?
They're both custodial.
Yeah, it's not a statutory definition, but.
It seems odd to me because it usually implies there's been a divorce, and there isn't always. I mean, the other thing that could happen is one of them has died, or there never was a father named on the birth certificate, and then I guess the mother's considered the custodial.
Do you want to change it to the parent having physical custody of the kid? And if you do that, then what if the parent has weekend visitation and they have physical custody of the kid for that particular period of time that the notice is sent out?
Right.
Well, I think you also have one other situation to consider, which is suppose the parents are divorced, they have joint custody, and they both have joint legal custody, which means they both have joint decision-making for major decisions for the child. Now, that's not a physical custody issue. That's who legally can make major life decisions for the child.
Well, you could address this just maybe by a sentence that says that, if a child has more than one custodial parent, then notice to one custodial parent is satisfies the requirement of the statute.
Well, this is Matt Whitman. This gets back to something that we put to bed 2 sections ago, which is the whole idea of having multiple fiduciaries existing at one time for the same person.
Right.
It doesn't work.
Right.
I mean, you can't have 2 people both occupying the same office and disagreeing, and that's why it doesn't work to say the custodial parent. You can say a custodial parent. I mean, this is why you can't have a GAL and a special representative at the same time for one person. They're mutually exclusive.
Unless it's the same person.
Right.
Well, that still confuses me.
Well, maybe we just need to define custodial parent in some way.
I recall that we discussed this, but I don't recall the reasoning why it was important to focus on the custodial parent rather than simply providing notice to both parents.
The reason, if I recall correctly, had to do with, let's say if it just said provide notice to a parent, that maybe the PR elects to send notice to the parent that would be less likely to object or less likely to fully represent the kiddo's interests. If that makes, I mean, there were some hypotheticals. There's always.
Is there a reason not to just send it to both parents? I mean,
Well,
yeah,
then
when you have unhappy divorces, you might be setting yourself up for some further disputes and arguments, but isn't that just kind of the nature of the beast?
Well,
I don't think we can write a statute that assumes all minors have divorced parents.
I think we have two different issues, though. One is providing notice to a minor's parents. And the assumption I think the assumption we may be making is that they would both be fiduciaries. But I think if providing notice to both, to a minor's parents doesn't necessarily mean you're providing notice to fiduciaries. You're providing notice to the minor's parents. Now, you may have parents who live together, they may be divorced, they may both come and say, we're the minor's parents and we want to, we're going to make the decisions. And if there's no problem with that and they're working together, then that's great. If they're not and they're working at cross purposes, then I think it falls to the court to make a determination. Okay, these are divorced parents and this parent does have the legal authority to make the decision. So you are the fiduciary. But again, that's not a question of notice. The question is, do we want to make sure a minor's parents, all the parents of a minor, know that this child is potentially have an interest in this will or not, and then let the fiduciary determination be left up to the court. And I don't see a problem with that.
Yeah, you're right. Subsection 1 just addresses who gets notice.
Right. The court will ultimately make the fiduciary determination if one needs to be made. So we don't have to determine whether they're divorced or living together or never married at all. That's a decision down the road. They all get notice, so they all know what's going on, and they can all come and make their pitch to the court.
Yep.
So if I could take us back to 4B, unfortunately, we have the same problem there. We say that, at least in option 2 for certain, and probably in option 1 pretty much the same, we say a minor may be represented by the minor's custodial parent. If the minor has 2 of them, that I think he gives equal rights to the 2, and if they disagree, we're all messed up.
It's true.
So what if we've now said, I'm going to draft a provision that requires the PR to request the court to make a determination about the representation, whether there's necessary representation for kiddo. Do we want to have the court address whether, providing notice to, dad instead of mom is the proper person to receive notice when it's a minor? How do you want to deal with that? I mean, in statute, so if you look at the dependency statutes, they all just say custodial parent. There's no definition of custodial parent. This is actually something that is a little bit of people are trying to get the term custody taken out of statute and instead use decision maker. So it's the parent with decision-making authority. We could use something like that instead. It's the parent that has financial decision-making authority over the child. Would that resolve it? I mean, that's kind of putting the onus on the PR to figure out who has financial decision-making authority.
Well, this is Jennifer, and what you might be able to do, the parents might just agree. And so if they can't agree, then that could be part of what you ask the court about. But because most of them are just going to say, sure, it can be mom or it can be dad. And, then you don't have that issue.
All right, so just to kind of go through that again. So the PR, we're telling the PR they have to make reasonable inquiry into the contact information for the kiddo's parents, both of them, right? And then the PR makes an inquiry to the parents about which parent should receive notice and then if the parents aren't able to come to an agreement, then when the PR makes the motion to the court about determining whether representation is necessary, they ask the court to also determine which parent should receive notice? Or in that case, would they be asking the court to appoint a special representative or a GAL as an alternate?
Well, this is Judge. Wouldn't it be easier for the PR just to give notice to both parents? And then if there's a fight, it's the parent's responsibility to say, no, no, I'm the one who should be representing the kid from here on out. It seems to put the PR in kind of an awkward position if the parents are at loggerheads. Who wants to have notice? Me, no, me, no, me. And why not just send them to both at the beginning and then figure out whether or not there's going to be a conflict? That's where they have the responsibility. Or, you know, if they're both absolutely awful, the PR can come in and say, court, I need you to make the decision because, I mean, maybe neither of the parents are appropriate. The grandparents are the ones who are the most appropriate for these kids. I mean,
which is the grandparent would then be appointed either the GAL or the rep, right?
Right, but the parents of the child have gotten notice, and then they both step forward to show how awful they are, as opposed to the PR trying to figure it out.
So part of the reason for sending the notice to the parents is for the parent, and part of the main reason for this provision in the bill is to codify that the parents have the authority to receive notice and consent and whatnot on behalf of the minor. So let's say we just say that you have to send notice to both parents, and we leave it at that. And then it'd be that both parents have authority to consent on behalf of the kiddo. But then if one parent consents, but one parent doesn't, at that point, what the parents are required to move the court for a determination of which parent has the authority to represent the kid?
It seems to me that after reasonable inquiry, if the personal representative can't, you know, make a determination about which one is more appropriate and the parents can't come to an agreement, yes, that's when it goes to the court.
Okay, so it would be at the beginning that when the PR is making that reasonable determination, that reasonable inquiry into the parents representing them, they would ask the parents to nominate a parent that would receive notice on behalf of the kid. And then if the parents aren't able to come to an agreement, then the PR moves the court for determination of which parent to receive notice or whether to appoint a fiduciary.
If
Do
we're
we
going down
need
that road, yeah.
Do we need to put that burden on the PR though? If we say PR, I don't know, wants to, PR is filing a motion for authorization to do something. And if PR provides notice to both parents and one of them informs PR that they consent and the other files an objection, well, then there's been an objection filed, and you know, can't we kind of just let the parents be the initiators of any dispute?
That's fair. So it would be the parent that doesn't consent would file an objection to whatever it is. And at that point, the court would schedule a hearing on it, and the parents would come in and argue their sides, and the court would make a determination. There would be no separate motion that the PR has to file. Is that right?
That's kind of my thought about it. I mean, this is all, we're talking about notice, and the purpose of notice is that if you want to object to an action, that's your opportunity to object. So if neither of the parents object, then great. And if one of them objects and the other doesn't and would want it, well, then there's a dispute, and that's ripe for the court to resolve.
Well, but then then there's a problem if you need to have a consent to a verified statement, and one of them signs the consent and the other doesn't, and I don't know, you can't do the verified statement if you don't have a consent. So it's not like notice of time to file objection and somebody objects.
Yeah, one of them's just sitting on their hands.
Well, in that regard, I mean, I was kind of thinking of this as you have co-trustees of a trust, and for whatever reason, the trust does not provide that one trustee can act without the other. And if that's the case, then you need signatures of both, right? So if you have a verified statement and I don't know, I mean, that's a burden.
I think there's also a mechanism, though, to address the parents sitting on their hands, which is, and we could still place the burden on the other parent, which is if one parent consents and one parent doesn't, then, you know, the parent who did consent or who doesn't consent could bring to the court some sort of, you know, request for a determination as to whether the parent who consented or didn't consent is acting in that child's best interest. So I think that there's still a mechanism for the court there to make a determination rather than requiring the PR to have to make a determination. I think it could still be, because I think that the idea here is to take as much work off the PR as possible on these determinations represented and put on the court. So I think there would still be a mechanism for the court to make a determination in the scenario we were just talking about as to whether the parent either withholding consent or giving consent, if the other parent makes an argument to the court that, well, they're doing this for this reason, not in the child's best interests, the court can still make a determination to move the process forward.
So in that case, we would want to say that either parent may bind the child and then create some additional provision that says, you know, the other parent can object.
So if we have this issue, you know, the dad is in jail and he's going to be a jailhouse lawyer, let's say, shouldn't there be some provision for the mother to come in at the front end and say, father is absolutely nuts, he's in prison for the next 50 years, I want to be the designated parent to receive it, and have the parent make that determination at the front end so everybody's not dealing with, you know, all the handwritten objections and everything else.
Yeah, and this is Lorianne. I think also you have to consider if there's a divorce order in place that gives one parent sole decision-making authority over the kid, do you really want to open up that can of worms that the parent who got screwed in the divorce, is going to object to everything just to antagonize the other parent? And really, if they basically lost all of their parental rights in the divorce, are we giving them back parental rights in the probate code?
Yeah, we don't want to do that.
No.
Some mechanism that says the court, you know, may make a determination that one of the parents is the appropriate person, or whatever language we want to make it.
Can we say that notice goes to the custodial parent, but if more than one parent has legal custody of the child, then the court makes a determination about which parent should receive notice?
Yeah, can I offer some practical observations here?
Please.
Where you're going to get this conflict, for the most part, is going to be, as a statement earlier about the grandparent might be the special rep. It's going to be the grandparent's estate. You're going to have two divorced parents. The grandparent is going to leave something to the kids. The ex-spouse is probably going to have antagonism towards the family, and it's the ex-spouse who's going to be grinding the axe. The other parent, it's his or her family, and they're going to be more receptive to it, and that's kind of be your conflict. And anytime, it's so easy for all of us to always say, well, let the judge decide. Every time we say that, in today's environment, it's 9+ months before the judge decides anything. And my question is, what do the rest of us do during those 9+ months while we're debating who's going to be the representative of this minor child?
We work on the rest of our estates.
Yeah.
So how about the parent with legal custody of the child, or if more than one parent has legal custody of the child, the parent that, you know, they can agree on who receives notice. And if they can't agree, then it goes to the court to make a decision.
Yeah, I would say either. If there's more than one, then either. And if the parents can't agree between themselves, then they have to resolve the matter. They have to bring the matter to the court for determination.
Would that resolve? I mean, I think that that's probably the cleanest way to do that in the probate code without delving into a whole bunch of family law.
I think that works.
That part, I agree that part works, but still, I still want something in there that says that I can keep on administering the estate while they're slugging it out.
Well, how would you keep on administering the estate if you're not able to provide notice to the kiddo?
The only notice that, well, you could give notice to both of them, and if you want, you know, but I want to just be able to move on. It's not going to, you know, if the notice that I'm concerned about in sub 2 is the notice of appointment of the PR. So if one requires you to make a reasonable effort to identify these people, then obviously you got to do that before you send notice of appointment, I presume. So then you're kind of hampered, because it's going to take a lot of diligence, and it's going to take some effort to find people before you can send that notice of appointment.
Well, let's go back though, because last meeting, and Lorianne did provide language in option 1 of 4B. We did exempt that initial notice to interested persons.
Okay. Well,
Just
that
because,
would be,
that could be a world full of people, and the PR is not going to have any idea, or, you know, may not have any idea or any way of knowing. And so we did exempt that initial notice of appointment.
And then in sub 2, I think the word "and" is troublesome. I mean, you have to send 3 notices. If I got a special representative appointed for somebody, why do I have to send a notice to the parent? And if you got a special representative for the minor, if they're over 14, why do you send them a notice? But once you get that notice out, then you know, you can administer the estate just fine. You can sell assets, you can pay bills, you can do all kinds of things until you get to a partial distribution or an accounting. You don't have a notice necessity for anything unless something unusual comes up. So most of the time you'll be able to administer the estate just fine.
I think you could.
Yeah. And then when you get to that circumstance where you need to give notice, or you need to get some kind of approval or something, well, that's just the way it is. You gotta fix it somehow at that point.
I'm looking forward to developing the section that addresses the certificate of compliance with all of this.
Yeah, really. Can I make another comment here? 4C makes it essentially impossible to get a verified statement. Because even if the representative consents to the verified statement, it's not effective unless the court approves it. So you got 9 months to wait to find out if what you did to shorten up the 20-day time period is effective.
But if the court says that it's effective, then you still don't have to prepare a full accounting. So there's
I don't know how any judge doing their job could possibly approve a verified statement. All they have is an inventory.
Well, it's not approving the verified statement. It's kind of authorizing the parent to consent to the verified statement.
Well, how can you do that without considering the substance of it?
Yeah.
Well, it might be based on the value that the kiddo is going to receive. If they're only going to receive $5,000, then the court probably wouldn't have an issue with the parent consenting to a verified statement.
Yeah, but what if they get 10% of the estate, which happens to be $5,000? But how do you know what 100% is? I mean, how do you know, how does any judge decide that waiving an accounting is a good thing to do without knowing what would be in the accounting.
Well, you know, this,
It's kind of crazy, you know, that this verified statement is a conscious choice to eliminate the protections of the probate code, which people are free to do.
this language is derived from the smaller group meeting that we had on the special representative and minor beneficiary or minor interested person language. And this was like back in May or June. And I think that Judge Cobb actually had the input on why she thought this was important. If I remember correctly, I might be misremembering, but Judge Cobb, are you still on the line?
Yes, I'm sorry, it got dropped, so I wasn't in on the first part.
Okay, so we're talking about in the draft of section 4C that deals with a minor interested person. Subsection 4C of that section talks about when a parent can, basically when a parent would be able to consent to a verified statement. And it's saying that if the kiddo's interest in the estate would exceed the amounts that are allowed to be distributed like under the statutes listed, that the consent is only effective upon court approval. And so the question is how that would work in practice with verified statements and whether the court would ever approve a parent's consent to a verified statement in that situation.
Well, and I think that my position back in May, and still is the case, is that a lot of it depends on, for example, the age of the child, and that's why we talked about the modifications to 116.083 to include the age, specifics of the property, who would be the fiduciary, and what would be the vehicle that would be received. For example, if it's a verified statement that says, you know, $5,000 goes to the 17-and-a-half-year-old, yeah, okay. As opposed to the kid is 2 years old and they're getting, you know, $750,000 and asking to have it submitted through a custodial account. No, I don't think so.
So in that situation where you, sorry, go ahead.
That my position was, if we're going to have this in approval of the statement in lieu of final account, which was in the original, one of the original drafts, if you're going to have that, my concern was have in that disclosed everything that the court would need to know to make a determination about whether or not it should be proved.
It sounds like an accounting.
Yeah.
No, this would be, it says, you know, Johnny Smith is going to receive $500. His age is 17 years, 6 months. He's going to receive it as a custodial and is, no, let's make it $50,000. The custodial account and his mother's going to be the custodian. That's what the disclosure would be. It's not an accounting.
Well, I'm not that comfortable with that. Let's say that Johnny gets 10% of the estate or 20% of the estate. And it's going to go into whatever, it's going to go to a conservatorship or a custodial account or whatever the will designates it goes to. There's no question about the effectiveness of the structure. The real question here is the child gets 20% of the estate and you get a verified statement that says the estate has $1 million of assets to distribute and 200,000 goes to the kid into this account or something. And they do a verified statement and everybody says that's good. And now the court has to approve the consent to the verified statement. And how do you know that the $1 million that's there is the right amount of money? How do you know that the estate should not have $1.2 million in it? And those are the kinds of questions I would think any jurist would have to ask. So
And that's sorry.
that's the problem with this court approval, is that you can't really approve a voluntary waiver of the accounting rules without knowing what an accounting would disclose. And it takes time, a lot of time, for a judge to approve anything.
So in the case where you've got $200,000 going to a minor beneficiary into a conservatorship account, wouldn't it be the conservator who would be consenting to the verified statement? Because at that point, you need to have a fiduciary appointed.
And basically, that's what I was arguing, that because this is what the version was. John, I'm not saying I'm advocating for this. This is what the version was. And I said, if you're going to have a verified statement, then you need to have full disclosure to the court so that the court can say, no, $200,000, go get yourself a conservator. And if the conservator, gets all the information from the personal representative and wants to consent, that's fine by me.
And that part's fine by me. If you're just looking at the mode of distribution, that's fine. But I just can't see how you can limit it to that. The statute says you've got to approve the decision to consent to a verified statement.
Lane, I just want to give a time check. We're at 4 minutes till 3.
Yeah, I don't think we're going to finish today.
We made it through 2 sections.
We did.
Sort of. We do have an assignment to Lori Ann, our faithful scribe, to redo section 4B option 2. That's some ground. Lori Ann, do you feel like you have enough to take another stab at 4C?
I can rework 4C to, well, we didn't really come to, I can try to throw something in there so it's a bit more clear that if there's, if the amount is going to, that the alternative to the parent consenting to a verified statement would be for the conservator who's going to actually be receiving or make it required that if the distribution is going to go into a conservatorship, that it needs to be the conservator who's consenting to a verified statement, not the parent. And then have, in all other instances, law. Yeah. But one option for now,
like a good analytical approach
that we can address, we can talk about in more detail next time.
So, and Sandy, I think we need a date sooner than later.
Yeah, I'm going to schedule it this week, and with the goal, we're going to have to do 2 meetings in September at a minimum.
Yep. Yeah, we've got to start making some progress here. This is slow going.
Next time it would be, it might be helpful. So I will get a redraft over to Sandy so that he can state that when he sends out the, let's set up a meeting.
Yeah.
If y'all could take a look at that, and before the meeting, if you have questions or comments about how things are working, if you could let Sandy know. And then he can give those questions to me, and I can kind of come up with, I can look at them, and if it requires like reworking the language, I can come up with some alternative language.
Sure.
Yes.
This is Judge Donahue. Maybe I think that's a great idea, Lori. Maybe if we could do that in maybe like a track changes mode with comments circulating around, so everyone's kind of seeing what everyone else is thinking and everyone else is asking and everyone else is saying, and maybe that'll move the ball down the road a little bit faster than you folks having to try and field them individually from individual people.
Can you do that?
Oh yeah.
Okay.
Yeah, I can get that passed. I can get that passed along, and then also what I'm going to do now is I'm going to send out a scheduling link for the next 2 meetings, just so we get that on the calendar.
Okay, good.
Try to get one the first 2 weeks of September, one the last 2 weeks.
All right, thank you, everybody. Boy, tough work, but we made some progress today.
Yeah.
So that will conclude the meeting of today's Probate Complication Committee.
No kidding.
We'll see you next time.